all under rank 10, all under rank 25, 69, 73, 36, 72. क्या डिफरेंट किया था इन सब ने दूसरों से कि इनकी रैंक इतनी अच्छी आ गई? मैं इन सबकी सब कंडीशन थोड़ी बताता हूँ एग्जाम देते हुए. पार्ट ए दे रहे हो तुम. पार्ट ए इज अराउंड रीडिंग अराउंड 11,000 वर्ड्स. 11,000 वर्ड्स प्लस 75 क्वेश्चंस तुमको करने पड़ेंगे सॉल्व. कंफ्यूजिंग सीए क्वेश्चंस हटा दो तो द एग्जिस्टिंग reading comprehension and critical reasoning questions, they are divided around or clubbed around 12 plus different varieties of question. Assumption, agree disagree, strongly support, strongly oppose, inference, main point, everything and everything. You complete all of that ideally within 1.5 hours. Complete करके तुम आए, you are met with a question like this. Not even one of this question, 6 of these questions. That's not even the all of it. इसके बाद एक और essay तुम्हें लिखना पड़ता है 500 words. All of this you need to do. This मतलब 6 legal questions, answer to these questions plus a essay within a time frame of 1 hour. I know बहुत से बच्चों ने अभी तक ये कर लिया होगा, दिमाग में कैलकुलेशन बिठा लिया होगा कि हाँ 200 to 250 वर्ड का तो आंसर लिखने बोलते हैं, वो हो गए 5 क्वेश्चन, 5-6 क्वेश्चन, 1200 वर्ड्स, अब 500 वर्ड्स ऐसे 1750 to 1800 वर्ड्स पर मिनट इन 60 मिनट्स अगर लिखना है, पर मिनट देख लो, बस वही 30-31 वर्ड तो लिखने होते हैं. एवरेज ह्यूमन 25 लिख लेता है पर मिनट में. मैंने गूगल सर्च मार के देखा है, मैं भी लिख ही लूंगा एक साल की प्रैक्टिस में. दैट्स वेरी लॉन्ग. तुम्हें अगर लगता है कि दे आर आस्किंग फॉर आंसर्स टू ऑल दीज 6 क्वेश्चंस एंड लेंथी आंसर्स, दैट्स वेरी रॉन्ग. NLSAT में एक ट्रेंड देखोगे तुम तो ओवर द इयर्स दे हैव डिक्रीज द नंबर ऑफ लीगल क्वेश्चंस. On top of that, they have decreased the number of words they demand in each answer for these questions. So what do they want is not lengthy answers. They want answers that are critical. They want answers that are argumentative. They want answers that are opinionated. They want answers that provide some original thought. अब ये सब करोगे कैसे? ये सब करने के लिए you need entire year of practice, upskilling yourself through sectionals, through mock tests and everything. But इसमें प्रॉब्लम आ जाती है यार. To attempt those sections, to attempt those mock tests that others are already attempting in batches of LawFren, I need to learn something first. I don't know anything. मेरे को कुछ introductory knowledge ही नहीं है. So yes, for that matter guys, welcome back to our 10 days free NLSAT Lecture Marathon series. Today we are at day 3 wherein we will be discussing writing legal answers. In this video we will be discussing कि part B में जो legal questions है उनके answers को essentially लिखा कैसे जाता है. What is the structure of that? What are the general mistakes that you do? And while dealing with that we will be also dealing with how the questions are asked and how should you approach a question. I'll be doing a question with you. So yes, now that all of that is established, दिमाग में still remains कि okay, we are doing all of this to attempt sectionals, to attempt full length mock series so that we get better. But where do we get those mock tests? So yes, LawFren has got that for you too. Before that, you need to understand one thing, that we provide the best in the market mock tests. This is not a bogus advertisement. You can go and check. Either you can check in topper testimonials, either you can check their interviews on our website, on our YouTube channel, or you can compare side by side the mock test that you last attempted and the mock test that you will be attempting on 9th of July, which is the first all India ranked mock test for NLSAT 2026. इस mock test में ना, apart from the quality of questions that we will be providing, you will get feedback on every answer. You will get to know where do you actually stand in the crowd of all the people who will be attempting this exam. You will get to know that how well do you need to prepare. So yes, the added benefits of attempting this mock test is that the people who score really well in it, the All India rank 1 will get 100% off, All India rank 2 will get a 75% off, and All India rank 3 will get a 50% off on LawFren Pro NLSAT 2026 batch. This batch में you will get access to 6 of our prime batches for NLSAT 2026. In which you will be getting over 20 sectionals for part A, 20 sectionals for part B, 25 mock tests. Apart from that, lecture videos from multiple faculties. In addition to that, all through the year, जितने भी mock test हम निकाले and जितने भी batches हम निकाले, you get access to all of that. Even LawFren के NLSAT 2026 crash course के लिए भी जो batch निकलेगा ना, उसमें भी also you will get early access. So yes, what's the wait for? Let's gear up our preparation for the AIMT on 9th of July. and let's start studying how to write legal answers. Hey everyone, welcome back to the video. And I do realize दिमाग में बहुत ambiguity रहती है कि part B में actually पूछा क्या जाता है. It's obvious NLSAT does not reveal the questions that they ask in the papers as previous year questions on the website. So yes, if I had to provide you a crux, part B के जो legal questions हैं, they essentially ask you three things. Firstly, since they explicitly say you that no prior legal knowledge is necessary, matlab you do not need to go around citing any statutes, you do not need to go around citing any kind of provisions of the law or past very landmark case laws and all of that for that matter. You are provided with something hypothetical. You are given hypothetical laws, you are given hypothetical statutes. Based on that, you are provided a factual matrix. उस factual matrix में जो भी problem arise होगी, you will be asked to give an opinion on that problem regarding liability, regarding who is the actual owner of some kind of property in question and all of that. So you must be thinking, okay, I need to have a very good understanding of the law. No, you need to have a very good hold over logic to solve all these questions. Very good hold over logic. Secondly, you need to know how to frame your answers correctly. The reason being, the people who actually will be checking these answer sheets are people who are the running faculties of NLSIU itself. These are people of law who are accustomed to a very particular way of writing. So yes, your answers need not have legal nitty-gritties. What they need to have is a legal flair while you write those answers. Secondly, the one great challenge that you will be facing while writing these answers is mental exhaustion. You will be exhausted after 1.5 hours of attempting 75 multiple choice questions. Although they are objective, still they take a toll. So after that exhaustive 1.5 hours, Abhi, you not only need to read the questions, not only need to formulate the answers, but you also need to write all of them under the single time frame of what? 1 hour. So here your tenacity is tested. पूरे एक साल में how much you have practiced and what are the skills that you have gained, that is tested. With that said, if we go ahead and move and discuss what are the various strategies that you can employ while writing legal answers. I have boiled it down to 4 primary strategies. There are a lot. I teach around over 15 I go in one class of the batch. But if I had to discuss with you like that कि basic क्या पता आना चाहिए. First of all, be very careful while reading the question. Read the factual matrix carefully. Factual matrix पढ़ के पहले समझो. You need not memorize it. I am not asking you to memorize it. But factual matrix पढ़ने के बाद तुम्हें clear होना चाहिए. Who is the appellant? Who is the respondent? Who is the petitioner? Who is the defendant? All of those things. Because if you're not clear with that, what happens is you just repeatedly go back to seeing who was what, and your answers are very shallow. इतने अच्छे आंसर्स तुम लिख नहीं पाते हो. सेकेंडली बी वेरी केयरफुल में ये कि बस फैक्चुअल मैट्रिक्स पढ़ के वो जो ऊपर लॉ दिया है, हाइपोथेटिकल लॉ या फिर स्टैट्यूट दिया है, उसको फैक्चुअल मैट्रिक्स पढ़ के नेवर स्टार्ट राइटिंग योर आंसर्स थिंकिंग ओके नेक्स्ट थिंग तो रिडंडेंट ही है, इट विल सेव टाइम. नो, रीड व्हाट एग्जैक्टली द क्वेश्चन इज आस्किंग टू यू. वो हमेशा पढ़ो क्वेश्चन पूछ क्या रहा है. फैक्ट्स पढ़ के खुद का क्वेश्चन बना के आंसर करने मत जाओ. क्वेश्चन ने पूछा कुछ और होगा, आंसर तुम कुछ और कर रहे होगे और वो मार्क नहीं होगा. क्योंकि जो आदमी कॉपी चेक कर रहा है ना, आदमी और फॉर दैट मैटर ही और शी और दे फॉर दैट मैटर विल बी चेकिंग द कॉपी बेस्ड ऑन अ मॉडल आंसर. एंड इफ योर पॉइंट्स डू नॉट मैच, मार्क्स कम मिलने वाले हैं. जितनी भी क्रिटिकल थिंकिंग कर लो, दैट विल बी वेस्टेड बिकॉज दैट्स नॉट ऑन द करेक्ट पॉइंट. So yes, be cautious while reading a passage to save yourself of this problem of rereading or assuming a different question while writing your answer. Secondly, for that matter, if I had to guide you about something, is identifying the issue. Lot of you do this initial mistake is thinking that the question is the issue. If the question is asking you something, that is not the issue. समझा देता हूँ. For example, Ram and Ravi are 2 school children. Factual matrix, can they go to Puri? Question. If you had to answer this question, would you start with the issue formation of can they go to Puri being the issue? No. The issue is something discrete. Issue is not the question. Issue actually leads to the answer of the question. So, issue formation is a very big hallmark of legal writing. How would I frame this issue in that Ram and Ravi scenario? Being 2 school-going children, do Ram and Ravi have the necessary resources and amenities to go to Puri? A. B. Being 2 minors and or interchangeably use it with 2 school-going children, Do Ram and Ravi have the permission from their parents to go to Puri? These are the issue. Answering these two issues will inadvertently answer your question ki can they go to the Puri or not. When that is justified, facing counter arguments is again something that a lot of us shy away from. You need to understand जब पैराग्राफ में फैक्चुअल मैट्रिक्स में या फिर क्वेश्चन के जस्ट पहले ही दिया गया है कि the other side is claiming this, you also need to engage with their claim also. You cannot just frame two issues, state your strong points and run away from the question. This will give you extra marks. Do not shy away from engaging critically. You need to strengthen your argument by weakening the other side. The best way to write an answer is, firstly, go ahead and tell your opinion regarding the same. What side do you support? Then after that, frame two issues. The first issue, frame completely in your paper favor, as in give arguments also to तुम्हारे favor में है. The second issue में painted something like they are arguing this. Does it stand or not? Then provide your arguments so that you are not just building your case but breaking their case. That shows that how thorough you are with your points. That shows confidence. That shows command over your answer. That is a very rare trait, and that is something that only rankers show. When that is also done, characterize it. A lot of things actually are given to you that you do not characterize well. First of all is a statute. Statute, as in you are given a statute, then read the statute properly. Do not repeat the statute in your answer. Repetition is very bad. It just shows that you do not put any thought into it. Think about the statute, break down the statute into parts, into clauses, tell how the statute works, tell about how do we need to interpret the statute. Sometimes the statute come around with words like public policy, reasonability. All of these need characterization. All of need this a bit of context, how reasonability works in this aspect, how public policy works in this aspect. For all these things, you need to characterize these terms, you need to characterize the statute. Herein you come between two things, the purposive interpretation and the textual interpretation. Textual interpretation is interpreting very strictly what you read in the statute. Purposive interpretation is using the terms of the statute, interpreting it as per the context, interpreting it as per the needs of the masses and everything. You need to choose a way in which you interpret, and for that you need to what? Draft your answer similarly. In the IRAC formula that we generally talk about, IRAC is the issue formation. Rule of law is understanding of what the novel law or the statute for that matter stands for and what does it mandates. The arguments follow thereon and thereafter. Got it? So yes, these are the various ways in which you can, are the various strategies in which you can write legal answers. If I move ahead and tell you about the various mistakes that you are going to commit and should not, are firstly slow and unstructured writing. Do not waste a lot of time in answering one question. The sole reason being it will eat up the time for other answers, and it will mentally burden you that okay, now you have less time to answer all the other questions, so that the answer that you can easily write within that given time frame also, you will mess those up in that tension. You are already in a lot of tension and exhaustion because of part A. Do not put yourself in the same cycle, to be honest a more rigid one, because you spend a lot of time in answering one question and do not leave ample time for the other. A lot of time what happens that some question we are confident in, तो उसमें होता क्या है ना, we go around writing a lot for that answer, thinking कि we will get more marks in this. Understand, more marks मतलब क्या? You would have got a 6 or 7, now you get a 8, on a very good day a 9. But for that you are losing on a 6 on the next 3 or 4 answers. Got it? So do not do that. Write all the answers on an equal footing, on an equal level. To be very honest, if you write more for an answer, it is more likely or more probable that you're going to lose marks for that. Because when that happens, most of your content, God forbid, and don't do that, but some of your content will obviously move beyond the contours of what the question demands. So yes, that is a mistake you should not commit. Secondly, do not repeat facts. Most of the time you just rephrase and rehearse everything that has been said in the question. Your arguments are just rephrasing the arguments for the question, what were already there in the question. Your rule of law, of your understanding of the law, is not just a purposive or textual interpretation. It's just a repetition of what has been said. Do not do that. That shows no reasoning, and that also makes the examiner want to mark you very negatively, so that you are not made to qualify for the rank list and all, because they severely critic people who do this. So yes, do not do this. Apply your own brain. Do not just summarize and write stuff in the answer. And don't use legal jargon. I understand I talk a lot about legal flair while writing, but that does not mean you jargonize your entire text. What does it mean? Do not go around and throw those legal quotes like ubi jus ibi remedium, where there is a right there is a remedy, or res ipsa loquitur. Do not go around and throw it like that. You can rather use phrases like suo moto, per incurium. So ये सब तो मैं बता दूंगा बैच में. I generally take a class wherein I tell you a lot of phrases wherein you can introduce a issue, or issue introduce करना है तो you start with this line. When you want to conclude, you start with this line. Few quotes also I tell you you can use this quote or that quote. Like Justice Holmes has a very famous saying: "The life of law is not logic; it's experience." Got it? So, or you can stand with quotes or definitions of law, that law is the command of the sovereign sanctioned by ye and all. So yes, all of those things you can start with, but do not jargonize. Use it like as per your, not as per your taste. What am I saying? But use it very cautiously so that it adds beauty and flair to your language, to your answers, but does not burden them with usually with unnecessary information. So yes, now that we are very clear with all of that part, let us now go and check a very good question. This question, as you can see on your screen, is one of the questions that I discussed in the batches wala class also. And this question was actually revealed, provided by NLSAT ke only. This was provided by NLSIU. This is a sample problem they provide. So yes, our main motive while reading this question is not to solve the question, but is to point out various things. We need to understand how to read a question, and we need to understand how to think while answering it. In the fictional city of Lakeview, read it with me. A law exists stating any individual, any, who causes harm to another person, directly or indirectly, leading to severe injury, shall be subject to criminal liability. From the first part, establishment of liability occurs. Liability can occur if the harm has been caused directly or indirectly, ठीक है, और कोई भी इंडिविजुअल करे तो harm होगा. However being a ये word, qualifying word, an individual may use. Individual can use reasonable, may use reasonable and proportionate. Words like reasonable and proportionate, you need to characterize this. What does reasonable mean? What does proportionate mean? In year of criminal liability, if one hits you with a stick, you shoot him with a gun. Is that reasonable? Is that proportionate? You need to characterize them while explaining the statute. Defend themselves or others from imminent harm. What is imminent harm? No, it's not just harm, it's imminent harm. Even if such action may cause harm to aggressor. Even if while protecting, aggressor को harm होता है. So long as the force is used to avert the minimum required threat. Minimum threat को, ठीक है. So long the force is minimum to avert the threat. ठीक है, दो तीन चीजें. Liability कब establish होगी? Directly and indirectly harm हुआ तो. बच कैसे सकते हैं? Reasonable proportionate force अगर तुम use करो तो, to defend each other और किसी और को imminent harm से. इवन में उसमें भी अगर अग्रेसर को हार्म हो गया तो उसमें भी बच सकते हो if the force is minimum. Got it? One night, Mrs. Singh, known for her expertise in cybersecurity, read it through. I am reading it silently. She had informed the relevant authorities by demonstrating the law. When she contacted relevant authorities, किसी ने उनकी बात नहीं सुनी. Got it? Since she was not being believed, decided to demonstrate the flaws. Okay, she triggered an emergency system by remotely accessing. However, widespread panic, emergency services failed. इसके बीच, okay, एक motorcyclist was harmed, indirectly causing harm. What was the intention? To improve public safety. And she could not have foreseen. What is the question? Very important for us to note. Should she be held criminal liable? Should she be held criminal liable? How do you frame the issues? Two very easy issues I am framing for you. A. Is she liable for criminal conduct as per the purview of the statute? Uska answer, yes. Why? Because the statute says that direct or indirect harm हो तो क्या होगा? Criminal liability होगी. Very good. B. Is she saved by the caveat carved by the statute wherein she is trying to use reasonable and proportionate force to defend herself and others from imminent harm? No. The force she used was not A. Reasonable or not proportionate. Why not reasonable? She could have filed a suit. Alternate दो ना. Reasonable क्यों नहीं है? Reasonable outcome क्या होता? To this indifference by the state. File a suit. Proportionate force क्या होता? File a suit, send notices, legal notices to them. Reasonable and proportionate. Imminent harm. What was she trying to save the people from? From imminent harm? No. Public safety improve करना चाहती थी. इमिनेंट हार्म को ऐसे कैरेक्टराइज करो कि अ बुलेट इज फ्लाइंग टुवर्ड्स यू, समवन इज पुशेस यू फ्रॉम इट्स वे, दैट इज सेविंग यू फ्रॉम इमिनेंट हार्म. गॉट इट? तो हो गया. लायबल क्रिमिनली नॉट सेव्ड बाय द कैवियर. उनका ये क्या था? फोर्सिएबिलिटी. इज फोर्सिएबिलिटी अ पॉइंट? नो, फोर्सिएबिलिटी इज नॉट अ पॉइंट. फोर्थली, यू कैन ऑल्सो पॉइंट दिस आउट कि देखो, caveat could have been carved if the harm that was caused by her was to the aggressor. Under the purview of the statute, aggressor को harm हो while exercising minimum force, then that could be saved. The force she used was neither minimum nor reasonable, not proportionate, nothing, and was not even saving you from imminent harm. Plus, the harm that she inflicted was not on the aggressor, it was on an innocent person. So for that, from the purview of that innocent person, she is guilty of criminal liability. This is how you conduct a thinking, thought-based analysis of a question, wherein you frame questions, wherein you frame issues के लिए argument, take up their argument. मैंने उनका forcibility वाला argument लिया, उसको thrash किया, then I frame the conclusion. This is something how you navigate through the questions. And yes, so I hope it was clear to you. This was Surya, and in this video we discussed legal answer writing. I hope it was really beneficial for you. Stay tuned for the further videos, and yes, keep learning, and as we say at LawFren, aim to be.
Are you preparing for 3-year LLB entrance exams but feeling overwhelmed and unsure where to start? Do you struggle with finding the right resources, guidance and clarity all in one place? Tired of institutions selling just mock tests or rebranding old materials meant for other exams and charging a fortune for it? Introducing LawFren, your one-stop solution for 3-year LLB entrance exams. LawFren brings you cutting-edge tools to supercharge your preparation. With our exams portal, you can participate in live All India tests and instantly see your rank, giving you real-time insights into your performance. Practice questions on individual topics, sharpen your skills, and get exam ready with confidence. LawFren, aim to be.